Good morning, Mr. Secretary. Am I audible?
Good morning, Hank. You are audible.
Thank you very much. Nice to hear your voice again. How are you?
No, I'm okay. How are you?
We're surviving, thank you.
It would have been much better, seeing you in person.
Yeah, Vonani, but you know that I'm not very keen on going to Cape Town after having done so for 30 years. So
Yeah, it has been a very long period of time.
just a quick personal uh, observation. You remember I met you when you were still working for PMG.
Yeah, that was around about, early 2000, I think. Yeah.
Yeah, around about 2005, 2006.
Yeah.
And you told me that you're going to join the portfolio committee, and I think you joined an excellent outfit. So, congratulations from a personal point of view.
Yeah, it has been a long period of time.
Yeah, yeah.
Uh,
Colleagues or the Secretariat, the National Director, can I ask, are we actually due to start at 9:30? Because we thought it was 9 a.m.
Good morning, NDPP. We are starting at 9:30.
Starting at 9:30. All right,
Okay.
we will be on. Thank you very much.
Yeah. Okay.
Recording in progress.
Good morning, members.
Good morning, Chair. Morning, members.
Good morning, and DPP. Members, today we'll be dealing with the proposed 20th and the 21st Constitutional Amendment Bill, which is a private members bill put forward by one of our own members, Honorable Breitenbach. So as part of interacting with the private members bill, we have called institutions that report to the committee that whose work may be affected by the private members bill proposed by one of Breitenbach. So we have with us today, we have the Department of Justice and Constitutional Development, which will do the first presentation. And then we'll have the National Prosecuting Authority. And we'll have the Information Regulator for the 20th Proposed Amendment Bill. Then for the 21st Proposed Amendment Bill, we'll have the Department of Justice and NPA. Members, you would have noticed that in part of the program, there was the NECAC, who was supposed to be part of us, but it has come to our attention that there are some of the executive processes that they need to undertake before they make their own presentation to Parliament. They are an advisory council to the President. So we'll reschedule them accordingly when they have undergone the due process that they ought to undergo. Committee Secretary, can you confirm the attendance of the Department of Justice?
Good morning, Chair. The department is in attendance. I've just seen the Deputy Minister is also here. The NPA and the Information Regulator are also in attendance.
Thank you very much. Members, we have received an apology from the Minister of Justice and Constitutional Development, Honorable Kubai, who is now engaged in one of his cabinet duties, but she has promised that she will be with us shortly. We've had an apology from Honorable Matafa, who also is committed in various parliament obligations. So he has indicated that won't be able to make it. Honorable Breitenbach, I will take you after the apologies. Committee Secretary, do we have any further apologies? Committee Secretary? Committee Secretary? Mr. Ramano? Okay. Members, am I audible?
Yes.
Yes, Chair, I can hear you.
I was asking Committee Secretary if we have further apologies.
Chair, no, no, I don't have any from my side.
Thank you very much. Honorable Bredenbach, I saw your hand was up.
Thank you, Chair. Good morning and good morning to everybody. I unfortunately have to leave at 11. But Mr. Klopper will stay on and he's perfectly able to deal with any issues that may need dealing with. So there's not a problem. And then, Chair, before we start, I would like to express my personal condolences to the National Prosecuting Authority on the passing of Advocate de Kock. I had a lot of professional respect for him, but he was a very decent human being and a very good man. So my sincere condolences to the NPA. It's a great loss.
Thank you very much, Honorable Bredenbach. Indeed, this is our first meeting with the NPA after the untimely passing of Advocate de Kock. But fortunately, we've been accorded an opportunity to go and pay on behalf of Parliament condolences in the memorial services, in the memorial service of Advocate de Kock in the NPA headquarters. So indeed, we are continuously going to pay our respect to Advocate de Kock, an outstanding civil servant. Honorable Nomvalo, I see your hand is up.
Good morning, Chairperson, and good morning to the committee and to our visitors. No, I just want to send my apology. I'm not going to be fully active in the meeting because we've got a party caucus. So I'm actually multitasking like yesterday. So I'm here in the meeting, but I'm not going to be fully active. I just wanted to tender that apology. Thank you.
Thank you very much, Honorable Nomvalo. That is well noted. DM Nel, can the department now start with the presentation on the proposed cyber crime commissioner?
Chairperson, thank you very, very much, and good morning to all members of the committee, the officials of the department, the National Director of Public Prosecutions, and also the members of the Information Regulator. I have not seen whether Advocate Klakula is on the platform, but I do see Ms. Tilly and probably others as well. Chairperson, maybe just to start with a more general comment on both the proposed 20th and 21st amendments to the Constitution. And just to extend our heartfelt thanks and appreciation to the Honourable Breitenbach for the concern that she has shown for two matters of vital importance to our country and concern to all South Africans. The first obviously being the fight against corruption and state capture, and the second being the very vexed issue of cyber security, which increasingly is becoming a global concern that is affecting our country, both in the private sector as well as the public sector. And I think it's a matter of public record that the Department of Justice and Constitutional Development itself has been a victim of cyber attacks, and specifically in the form of a ransomware attack that had devastating consequences for the operation of the department and many of the services that it renders. So it's in that context that we really welcome the initiative by members of parliament, public representatives duly elected by the people of our country, who go the extra mile in the fulfillment of their legislative functions. At the same time, I think the Constitution vests the responsibility for both the development of policy as well as the formulation of legislation with the executive. And I think just to say up front that there are quite extensive processes currently underway, some of them at quite an advanced stage within the executive, dealing with both the matters of cybersecurity and then obviously also the fight against corruption. So with that, I would like to hand over to the Director General, Advocate Doc Mashabane, to introduce the team led by Deputy Director General Ms. Advocate Calais Pillay, and who's the DDG responsible for legislation, legislative development, and the team that will be assisting her. Chairperson, if you could maybe deal with that cyber intrusion. I think without wanting to preempt the presentations, I think we would say that we welcome the initiative by the Honourable Breitenbach, the tremendous amount of thought and research that's gone into her proposals. We would propose that that those efforts could be very usefully directed to assist the processes currently underway in the executive. Chairperson, but with that, through you to the Director General. Thank you.
Thank you. DG.
Thank you very much, Honorable Chair, and thank you very much to the Deputy Minister, and good morning to all the honorable members of the committee. I will not take much time. I'll ask my colleague, the Deputy Director General for Legislative Development and Legal Services, Calais Pillay, to upload and take the committee through the presentation. Thank you very much, Chair.
Thank you. DDG Pillay.
Good morning, Chairperson and honorable members, Deputy Minister, and all those attending the meeting this morning.
Can we see you today?
Yes, Chairperson.
You have been hiding the entire week.
No, I intermittently come online. Sorry about that, Chairperson.
Okay.
My reception is not very good, so if I may switch off my camera, if that's okay.
Yes, okay. Okay.
Thank you. Chair, I do not have sharing rights, so I'm just waiting for either the portfolio committee host to share, or if Ms. Tabisile Mahlangu can share. But in the meantime, if I may proceed, because I think we have submitted the presentations, if that's okay.
They have made you a co-host now.
Oh, they have?
Yes.
Okay. Okay, thank you, Chair. In this presentation, Chairperson, we deal with the purpose of the bill and our presentation, an introduction, and some substantial issues which we will deal with accordingly as we proceed. Just trying to get it onto a slide presentation. Okay. My presentation is visible, I hope, Chair.
It was visible, but it's no longer visible now. It's back again.
Okay, thank you, Chair. I've gone through the purpose of our presentation today. And I move on to slide 3 of the presentation with regard to the substantial issues. By way of introduction, Chairperson, the 20th Amendment Bill, the rationale behind this amendment bill is, in short, at present, South African departments and critical infrastructure are not sufficiently protected against cyber threats. They are also not properly equipped with protecting sensitive public information against hacks, and current legislation dealing with cybersecurity is either insufficient or only deals with the consequences. And in this regard, Chair, I refer to page 6 of the objects memorandum. With regard to the substantial issues, Chairperson, I would like to start off by speaking to the report of the ad hoc committee on the review of Chapter 9 institutions, Chapter 9 and associated institutions from 2007, which was a while ago, but the report remains relevant to guide into any consideration to create further Chapter 9 institutions. The ad hoc committee was tasked to review state institutions supporting constitutional democracy as listed in Chapter 9 of the Constitution. The so-called Chapter 9 institutions, as well as the Public Service Commission as established in Chapter 10. To broadly assess whether the current and intended constitutional and legal mandates of these institutions are suitable for the South African environment, whether the consumption of resources by the institutions is justified in relation to their outputs and contribution to democracy, whether a rationalization of functions, role, or organization is desirable or will diminish the focus on important areas, and to conduct a review with reference to other organs of state of a similar nature whose work related closely to the work of the above-mentioned institutions. The ad hoc committee was also tasked with looking into individual institutions to review the appropriateness of the appointment and employment arrangements for commissions and their secretariats with a view to enhance consistency, coherence, accountability, and affordability, reviewing institutional governance arrangements in order to develop a model of internal accountability and efficiency, improving the coordination of work between institutions covered in this review, as well as improving coordination and cooperation with government and civil society, recognizing the need for a more structured oversight role by Parliament in the context of their independence, and reviewing the funding models of the institutions, including funding derived from transfers and licenses and other fees, with a view to improving accountability, independence, and efficiency. The broad recommendations of the ad hoc committee are as follows. With regard to financial and budget arrangements, the ad hoc committee found that there were inconsistent budget processes and budgets should be directly defrayed from Parliament. Appointments, there was inconsistency. Let me state it differently as stated in the presentation. Consistency in appointment processes are required. With regard to the relationship with Parliament, Parliament's engagement with the institutions are inadequate and improvements are required. Institutional and governance arrangements. Internal tensions have been experienced in most of the institutions. This is often the result of the absence of clear lines of authority. Legislation is required to clarify roles of authority. Accessibility, the institutions are urban-based and should become more accessible to the public and rural areas. And the Commission also recommended consideration be given to a single human rights body. And in this regard, the committee said, the multiplicity of institutions created to protect and promote the rights of specific constituencies in South Africa, as in practice resulted in an uneven spread of available resources and capacities, with implications for effectiveness and efficiency. And it proposes the establishment of an umbrella human rights body. Chairperson, in the following slides, we go into the substance of the 20th Amendment Bill, and I would like Advocate du Preez to now come in and deal with the rest of this presentation. But just to state that the comments with regard to the ad hoc committee are also relevant to the 21st Amendment Bill, although not specifically included in that presentation as well. Thank you, Chairperson. May I hand over to Advocate du Preez?
Okay. Advocate du Preez.
Good morning, Mr. Chairperson, members of the committee, and our Deputy Minister. Dealing with the substantial issues that we have identified with regard to the 20th Amendment Bill, Chair, is that an important concern with regard to the proposed establishment of the Cyber Commissioner is the question whether the fiscus will be able to fund the creation of an institution that will require vast financial and human resources, bearing in mind the very wide powers, functions, and duties envisaged for the Cyber Commissioner to exercise. An amendment of this nature, which proposes the creation of a new entity, must include detailed costing of current and proposed amendments to enable proper deliberation. And then the provisional costing must also be conducted to consider the possible financial implications of the eventual national legislation to be enacted in terms of the proposed section 192 capital A of the Constitution. My apologies. During the initial drafting and presentation of the Cybercrimes Act, Mr. Chair, we would like to point out that the bills as consulted upon combined both cybercrimes and cybersecurity. The bill was then split into cybercrimes on the one hand and cybersecurity on the other hand, as it was feared that the protracted deliberation on the two aspects would delay the criminalization of cybercrimes, which was urgently required at that time. The enactment of the Cybercrimes Act followed the approval of the National Cybersecurity Policy Framework by Cabinet in 2012. The Cybersecurity Hub has been established under the mandate of the Department of Communications and Digital Technologies. The Cybersecurity Hub is South Africa's security incident response team, which is currently in existence and operational. And then on the next slide, we indicate that the State Security Agency has since undertaken work on the development of cybersecurity legislation. Part of this work includes an initiative to conduct an audit of all existing statutory structures and institutions exercising oversight over and performing powers, duties and functions in respect of cybersecurity. Mr. Chair, this work is being undertaken through the Cybersecurity Response Committee, comprising of several government departments, and we have noted them there for you, a few of them. And there are various structures exercising powers with regard to cybercrime and cybersecurity. The question may therefore be raised, Mr. Chair, whether it is still necessary to amend the Constitution to establish a commission of this sort as a Chapter 9 institution. The Cybersecurity Hub is South Africa's National Computer Security Incident Response Team, with the abbreviation. The hub is to be a central point of contact for private sectors, civil society, and citizens in order to enhance collaboration and promote a coordinated response to cybersecurity, including inter alia incident coordination, information dissemination, awareness building, and then the establishment of the National Computer Security Incident Response Team, and the creation and promotion of national standards. And existing institutions such as this ought to be strengthened and supported to carry out its mandate, Mr. Chair. The Portfolio Committee is advised to consider whether there is a sufficient basis to create a new constitutional entity as proposed in the 20th Amendment Bill over the above and existing efforts. More particularly, if there is a lack of resources and expertise hampering current efforts, it is unclear how this problem will be resolved with the creation of a new entity. Consolidating functions with a single entity will still require the performance of functions by various sectors, both private and public. And Mr. Chair, our Deputy Minister has emphasized the cross-cutting effect that it must apply to both private and public spheres. If coordination is indeed a problem, then these can be addressed through better management and various structures. Thank you, Chair. My apologies, Chair. It is therefore imperative that all relevant government entities and private sector partners who have been collaborating with government to ensure a safer cyberspace be engaged on the feasibility of creating a new entity in the Constitution to avoid duplication of functions and the wastage of resources. Apart from technical concerns with regard to the provisions contained in the 20th Amendment Bill, the department is concerned that a period of 12 months will not be sufficient or practical to comply with the passing of the legislation required, Mr. Chair. If the amendment is proceeded with in clause 5 is accepted as proposed, the amount of work to be invested in a major piece of legislation will eventually just simply require the drafting of the legislation, the costing, the sourcing of funding, and conducting and concluding a socioeconomic impact assessment process and consultation in respect thereof. Well, we cannot from our experience see that it will be completed within a 12-month period. Mr. Chair, I think that concludes. Mr. Chair, in paragraph 6 of the objects memo of the 20th Amendment Bill, it is indicated that experts in the field of cybersecurity, including a cyber forensic expert a cyber criminal law expert and a senior lecturer in cybersecurity were consulted during the drafting of the bill. Mr. Chair, we would like to point out that taking into consideration that the information regulator exercises oversight over and ensure compliance with the Promotion of Access to Information Act and the Protection of Personal Information Act, it would have been advisable for the drafters, Mr. Chair, to have consulted at least with the information regulator in respect of the proposed powers, duties, and functions of the Cyber Commissioner. The objects of the amendment bill foresee the possibility of the proposed Cyber Commissioner replacing the role of the information regulator over time. Mr. Chair, it is submitted that the PC Portfolio Committee should consider inviting the National Treasury as well to address the Portfolio Committee on the feasibility of the 20th Amendment Bill. With that, I conclude, Chair. Thank you very much.
Thank you very much, Advocate peer-to-peer. NDPP, can we now receive a presentation from the NPA? NDPP?
Yes, thank you. Now, Chair, we do not have a presentation on this amendment bill. We'll only be dealing with the 21st Amendment Bill. But my colleague here did raise the question about inputs from CETA in this discussion as well. Thank you, Chair.
Thank you very much. Advocate Tlakula, are you in the meeting?
Chairperson,
Honorable Mashala?
no, thanks so much, man, for opportunity. I just want to check with the national, the NDPP, Director of Public Prosecution, when she says that she doesn't have a report in terms of this bill. Does that mean that it is not necessary, or she's still gonna come with?
No. Honorable Mashala, look, let's do like this.
Or is not part of this?
Honorable Mashala?
Yes.
Let's do like this. Let's receive from the department. NPA made a submission. Then we're going to get information regulator. Then we get members to comment in all the three.
Okay, thank you.
Sure. Advocate Tlakula, are you in the meeting? Who is representing the information regulator?
Then I've been in the meeting. Good morning. Even when the deputy minister was saying whether I was in the meeting or not, I was in the meeting. Good morning.
Oh, you didn't indicate, Chair.
I didn't want to interrupt.
You just kept hidden under the table.
I'm too old. I won't fit under my knees won't go under the table, Chairperson.
Okay, Chair, you may proceed. Yeah, proceed.
Thank you very much. Good morning to you, Honorable Chairperson, honorable members of the committee, the Deputy Minister, and all the officials of the Justice Cluster, including the DG and the National Director of Public Prosecution. We have a presentation which is going to be done by Advocate Wiganyo. But before he does that, I think if you permit me, I'll make a few preliminary remarks. The first one is to really echo the words of the Deputy Minister that indeed cybersecurity is it's a major challenge in our country and that it has to be addressed. The second one, I think, is just to also weigh in on the presentation by Advocate Pillay. Chairperson, as you know, I've been around for a long time. In 1995, I had the privilege of being one of the first members of the South African Human Rights Commission. At that time, the Human Rights Commission was the only, it was one of the two constitutional structures, which was the Human Rights Commission and the Public Protector. And at that time, we wrote a document called the Proliferation of Human Rights Institutions. And we proposed that there should be a single human rights body along the lines of Australia, which will have various components. It will be a Human Rights Commission with a Commissioner for Gender Equality, Commissioner for this and that. And that proposal culminated, I think, at some point long after we had left, with a document that was produced by the late Professor Asmal, and may his soul rest in peace. And it's been many years, 30 years, we are back to the same conversation. There has now been another ad hoc committee that looked at this issue as well. I'm just putting this on the table to say we have traveled a long way as far as this matter of proliferation of human rights institutions is concerned in this country. Now, coming to my short remarks that I'm going to make before I hand over to Advocate Buikanyo. You know, Chairperson, you have been there, you were there probably when we were established, and we being the information regulator in 2016. And since then, we have been at pains and lobbying the portfolio committee that we should be included in the Constitution as a Chapter 9 institution because our functions mandate are akin to a constitutional body. Of course, we did not succeed with that because it was felt that at some point we're told that it's difficult to amend a constitution if you open it up, there could be other things that can creep in. So we see now that it is indeed possible to amend the constitution to create another body, the Cyber Security Commission. On our side, as you know, we as the information regulator, we have gone through the pain of establishing a new institution. And it is a big challenge in the current fiscal, with the current fiscal constraints that we have. We have a large mandate with a small budget for the mandate that we have and the complexities of the issues that we are dealing with. The second issue is that you would know that we also deal with some aspects of cybersecurity in terms of Section 19 of POPIA that talks about security compromises. So we have developed expertise in that aspect. And we also have recruited people that we have trained on aspects of cybersecurity related to our work. There's a dearth of experts in this country on cybersecurity. And we are a training ground because we conduct assessments on cybersecurity aspects that relate to our mandate. So we have acquired those expertise. It's difficult to keep them because the private sector poaches them. So we train and they leave, we have to train again. And that's what we are battling with. Budget is a big challenge. Establishing a new institution in these financial constraints that we have, it's difficult. Maybe it's better to capacitate the existing institutions instead of creating new ones. Our concrete proposal, Chair, which Advocate Buikanyo will elaborate on, is if it's possible to amend the Constitution and establish a body that will have a similar mandate somewhat with the information regulator. Why don't we create an institution in the Constitution? Whatever we name it, it could be the Information Commission, and it will have a commissioner for access to information, a commissioner for protection of personal information or privacy commissioner, and a cyber security commissioner. There are examples globally where such commissions exist that deal with these mandates, particularly because if you look at the bill, it deals with or proposes to deal with some of the issues or some of the mandate of the information regulator. Let me stop here then and hand over to Advocate Bukanyo with your permission, Chairperson. Thank you.
Thank you, Advocate Bukanyo.
Thank you very much, Chairperson and honorable members of the Portfolio Committee. What I'm going to attempt to do, Chairperson of the Portfolio Committee, is to really summarize. Am I audible, Chairperson?
Yes, you are, but is it possible that we see you?
Oh, apologies. Are you able to see me, Chairperson?
Yes, we see you.
Thank you very much, Chairperson. The network is a little unstable, Chairperson. So if you would allow me to just switch off the camera with your indulgence.
Yeah, you are allowed.
Thank you very much, Chairperson. Chairperson and honorable members, I am going to try and summarize because most of the issues that we will also be presenting on have been touched on also by Advocate Dupree and Ms. Pillay in their presentations. So we and the chairperson of the Information Regulator, Advocate Tlakula. So what I'm going to attempt to do is to summarize the first few slides so that I don't take up unnecessary take up time of the Portfolio Committee. I'm going to start off with our background as the Information Regulator, essentially our mandate. We are created by Section 39 as an independent institution which owes its being to the Protection of Personal Information Act 4 of 2013, and specifically, as I've said, Section 39. And really the essence, Chairperson and honorable members of Section 39 is that it establishes us as a juristic person which is independent and is only subject to the Constitution and to the law. I think it is important for us to state that the establishment of the Information Regulator really came about as a result of years of study and research by the South African Law Reform Commission. And after these years, the South African Law Reform Commission came up with a recommendation that we should be established as a statutory agency, which would be responsible for two pieces of legislation, which was POPIA and BAIA, the Promotion of Access to Information. And really, Chairperson and honorable members, this was to ensure that there was a balance between these two competing rights that are entrenched in our Constitution, the right to privacy and the right of access to information. And I need to really emphasize the fact that in doing this, the Commission considered international standards and international best practices, as was also outlined, as was highlighted by Advocate Tlakula. And I think for the sake of being complete, Chairperson and honorable members, it is important to state that POPIA owes its genesis to the right to privacy as contained in Section 14, whilst BAIA owes its genesis to Section 32 of our Constitution. So therefore, the Information Regulator, when it was established to ensure that it gives effect to these two rights. We need to also emphasize that our legislative mandate is aptly summarized in Section 40 of POPIA, and essentially it is to provide education, to monitor and enforce compliance by private and public bodies, to handle complaints, and to conduct research. And this sort of work we do in terms of both pieces of legislation, which is on the BAIA side and on the POPIA side. Chairperson, it's important then, after having laid that background, for us then to immediately go into the essence of our submission. We are of the firm view that in terms of our submission, that creating a new institution such as the Cyber Commission will not have any positive impact in the regulation of both POPIA and BAIA. And we are saying this, Chairperson, especially if you have regard to the provisions of Section 2A, Roman figure 1 of POPIA, which provides, which effectively gives effect to the constitutional right to privacy by safeguarding personal information when processed by a responsible party, subject, and I'm quoting from the Act here, subject to justifiable limitations aimed at balancing the right to privacy against other rights, particularly the right of access to information. And I think regard should also be had, and this is what we say in our submission to Section 44, which essentially states that the regulator must have regard to the protection of all human rights and social interests that compete with the privacy, including the general desirability of the free flow of information. The one factor, Chairperson and honorable members, that we really want to highlight is really the shortcoming insofar as the mandate of the Cyber Commission is concerned. And essentially it is that it does not fully encompass all the aspects as provided for in the definition of processing as we have it in POPIA, as it only confines itself to instances of cybersecurity and processing that is only done through information technology infrastructure. The chairperson of the regulator, before I proceed, has highlighted the work that we have already, the extensive work that we've already done insofar as Section 89 of our Act is concerned. Section 89 of our Act provides that we may, on our own initiative, also conduct assessment, or at the request of responsible parties, conduct assessments. We have conducted this assessment in instances where there had been security compromises. And I'm going to just highlight some of the assessments that we've conducted. The members will note, Honorable Chairperson, that we conducted an assessment in relation to the Department of Justice. We also conducted assessments in relation to TransUnion, DISCAM, Government Employees Pension Fund, Development Bank of South Africa, South African Social Security Agency, SASSA. So those are some of the assessments that we conducted. And as the chairperson of the regulator, Advocate Lakula, has already mentioned, in doing this, we had to build capacity. We had to ensure that we had the necessary resources to enable us to deal with the dictates of the provisions of what Section 19 to 22 enjoined us to do, or of POPIA enjoined us to do. Now, we are further saying that the proposed bill creates a regulatory confusion and uncertainty, in a sense that if you look at the mandate of the Cyber Commissioner, whose legislative mandate includes establishing and maintaining cybersecurity capabilities for all organs of the state entities dealing with public information. That's the work that we already do in accordance with what I've already said. But if you look at the wording, it is also clear that it falls short. This mandate falls short of really addressing the security compromises or any cyber attacks that may be affecting private entities. And to that extent, we find that there's also a lacuna insofar as the work of that particular body will be concerned. Advocate Dupré mentioned the physical constraints that do not allow for the establishment of this new regulator. And we firmly agree with that proposal that was put forth by Advocate Dupré to say that in this current climate, the physical constraints would not allow for the establishment of a regulator. And we would then be creating a parallel structure that would also be touching on the mandate that is already being exercised by the Information Regulator of South Africa. And to this extent, there would be regulatory confusion insofar as this particular aspect is concerned, the regulation is concerned. So we can go to the next slide, Ms. Zondi. We are therefore, you can skip that one. I've already covered that one. We are also then saying that in line with what the chairperson of the regulator has said, we are emphasizing the issue of the amendment of the Constitution to say that we already have structures that are engaged in this particular work, and what we are proposing is that this structure should then be empowered The Constitution should then be amended. Ms. Zondi, you can go to the next slide. The Constitution, the slide after that. The Constitution should then be amended, and the mandate of bodies such as the Information Regulator should then be extended to ensure that it does this work that is proposed insofar as the Cyber Commissioner is concerned. There's been work that over years that has been done, and there's been benchmarking that has been conducted, and a lot of jurisdictions have been looked at insofar, and this we say in our submission, in our full submission, and the members may want to then look at what we are saying in relation to the other jurisdictions. But there are those jurisdictions where you have what the chairperson of the regulator, Advocate Lakula, had suggested in terms of the extended mandate. And in this instance, we are proposing that the constitution should then be amended in order to then extend the powers of the information regulator to ensure that it does this particular work, because this would then ensure that the country does not have to unnecessarily spend money on areas where there are already bodies that are already engaged in this particular work. Chairperson of the Portfolio Committee, I have summarized our submission, and I would then allow, with your indulgence, Advocate Lakula or any of the members, just to come in and amplify if there is anything that they want to emphasize. With your indulgence, Chairperson of the Portfolio Committee.
Thank you very much, Advocate Seppo. What we'll do now, we'll allow members to interact with the presentations. Then any form of enhancing what has been presented will be done in that slot. So members, can we interact in a form of clarities, in a form of comments, what has been presented by the Department of Justice, by the Information Regulator. The NPA is also here to attend to issues that will be directed to the Department of Justice as in relation to this proposed amendment bill. I see only Honorable Klopa. I see Honorable Swart, Honorable Zodetsi, and Honorable Mohlala. Honorable Klopa.
Thank you, Chair. Am I permitted to put off my video?
Yes, you can.
Thank you, Chair. Starting off, we spoke about the feasibility in establishing a new constitutional entity, as well as the costing and the consideration of the financial implications. Establishing a dedicated cybercrime commission could centralize efforts and resources, potentially leading to more effective and coordinated response to cyber threats. The centralization might ultimately result in cost saving and increased efficiency. And the question of what cybercrime costs South Africa has to be taken into account, Chairperson, as well as the attacks mentioned by the Deputy Minister in the beginning of the ransomware. Investing in a dedicated commission could lead to long-term savings, preventing costly cyber incidents and improving overall security posture of the country. And cost capacitating existing effective institutions will not be any cheaper than amalgamating the current new ones into more effective institution. Chairperson, the IR spoke about the Commissioner may replace the role of the responsibilities of the information as well as overlapping and so forth. I'd just like to know, have any of their assessments been proactive assessments? The Cyber Commissioner can provide a specialized focus on cybersecurity, enhancing the overall regulatory framework, clear delineation of roles and responsibilities, and that might mitigate any overlap that might be any of any concern there. Chairperson, sorry, I just made a few notes here. I'm just trying to get to that. Just give me a second, please. I've just lost my place here. If we're talking about cybersecurity, we're speaking of, the State Security Agency being tasked to to set up the legislation of this. I mean, is it really proper that a body or institution that doesn't report to anybody, has no oversight or supervision, actually sets up this legal framework which forms part of the legislation framework? Chairperson, I will leave it there. I don't have too much to say. I hope that I'll get some answers. Thank you, Chair.
Thank you, Honorable Glover. Honorable Swart.
Good morning, Chair. If you'd allow me to turn off my camera. Thank you so much. Chair, I think there are some very valid concerns that have been raised by the information regulator, and I think the very strong argument which was considered about the information regulator becoming a Chapter 9 institution is something that was considered and it could be considered in the future. I do, however, want to state very clearly that we see cyber technology increasing, and we see even the private sector really struggling with increased cyber crime. You see all the issues of information and bank accounts being scammed, accessed, even with the highest levels of security. And I think we as a committee need to obtain the inputs, consider the inputs, and consider the real feasibility of the proposal. I do also want to mention that I've also been around a long time, and I do recall the Cader Asmal report, which was very significant. Sadly, I don't think those recommendations were implemented at all, but I think it's also important to highlight that Chapter 9 does not, as presently worded, only deal with human rights issues, human rights institutions which support constitutional democracy. One of the very important bodies is, of course, the Auditor General that deals with public accounts, deals with public accounting. So there is a precedent, and of course we've got the Electoral Commission as well, which deals with elections. I think it's also important to realize that there is space for the creation of such a cybercrime commission, and we need to seriously deliberate on what impact that will have, whether it is desirable, and I think we can engage on that discussion on an ongoing basis. Thank you, Chair.
Thank you, Honorable Tsotetsi.
Thank you very much, Chair. And is there a need for me to briefly switch on the camera?
Yes.
Okay. No, thank you very much, Chair. Chair, I think the submissions around the need for the creation or the strengthening, rather, of cybersecurity is quite important. And I think we have to note it as a concern that really strengthens generally our security as a country. I think what we must be able to exhaust here is whether there is a need for the cybersecurity to be created into a commission or into a Chapter 9 entity. With all the concerns that have been raising, Chair, I think the appetite of continuously creating Chapter 9 entities really is beginning to lose taste. All the matters that are raised around the strengthening of our cybersecurity can all be located within the context of strengthening the information regulator or any other entity that speaks or deals with the security of, or generally our security. And I think that the information regulator would be the one that would need to be strengthened as far as that is concerned. I mean, there are many things that would, there are many implications here. The issue which has been raised, which is also what I know to be at the heart of Honorable Breitenbach, the question of the cost on the taxpayers. She consistently speaks about that as a genuine concern, and which we all agree with her. The very same taxpayers, will they be able to handle the creation of this kind of entity, which otherwise its responsibilities can just be plugged into the already existing entity as part of strengthening its operations and without necessarily having to start all the process of re-establishing a separate thing altogether. So my submission is that this is important, the content and the elevation of issues around the cybersecurity, they are all important. But what is unnecessary is the creation of the entity which is separate and which is going to be a Chapter 9 institutions. I think that the fiscals of the country are not going to be able to handle and support that. But also, I think over and above the question of the fiscals, the creation of that entity itself is unnecessary, as there are already entities that can only be strengthened and supported to respond to our need for cybersecurity, which is articulated as part of this this request that has been put before the committee. So that is the view, Chair, and we can always discuss it moving forward. But I think that those that would have brought the view forward need to be persuaded on the importance of strengthening the existing entities and ensuring that we don't necessarily create a system whereby we always establish something that is very new, as if the existing ones are unnecessary. Thank you very much.
Thank you, Honorable Mshala.
Thanks so much, Chair. I just wanna show myself on the video and then switch it off. Nos, thanks so much, Chairperson. We really appreciate this engagement and the approach on this matter. Chairperson, the NC government has continuously created institutions without ensuring their effectiveness. If we look at the 2007 ad hoc committee report on Chapter 9 institution highlighted, concerns about resources allocation, inefficiency, and duplication of mandates. Yet, instead of addressing these issues, then we come across this thing of now having to create another institution called the Chapter 9 institution of Cyber Commissioner. Chairperson, the reality is that the cybersecurity data protection and information regulation are already partially handled by existing bodies. I think I do agree with what the information regulator have stated in their report, such as the information regulator, the cyber security hub, and oversight mechanism under the Cyber Crimes Act. This issue is not actually a lack of institution, but poor coordination and underfunding. This is what we find ourselves in. So I think even if we come with this thing of creating another Chapter 9 institution, I think we need to go through that route of the information regulator. I think they've got a point. We're going to come with this one, but we have not included them. The POPIA, where are we putting the POPIA? Where are we putting the PAIA? So I think that route, what they have stipulated in this committee, I think for me, it will work for the government and it will work for us in terms of building a stronger, progressive constitution of the Republic of South Africa. Thank you so much, Chair.
Thank you very much, Mshala. Now we're going to take Justice TM, you'll start.
No.
That will take the regulator, Advocate Tlakula, just to make reflections on the comments and some of the questions, or further clarity kind of comments that have been said by members. You can proceed, Tim. You are muted, Tim.
Chairperson, thank you very much. I have your permission to keep my camera on.
It looks like yourself as well have got cyber problems.
Let me just, Chairperson. Yeah, no, thank you very much. And thank you very much for the very helpful inputs, both by the department and by the information regulator, and the interventions by the members. I just want to raise three points. The first is, I think we need also to go back to the basics of our constitution. If one looks at chapter 9, it says there in section 181 2, well, first of all, it starts off by outlining the state institutions that strengthen constitutional democracy in the Republic. And those institutions are the Public Protector, the Human Rights Commission, the Commission for the Promotion and Protection of the Rights of Cultural, Religious and Linguistic Communities, the Commission for Gender Equality, the Auditor General, and the Electoral Commission. Now, whilst that's quite a diverse range of institutions, there is a common thread that runs through them, and that they all, in one way or another, advance and protect and help to realize certain rights that are contained in the Constitution. The Constitution goes on to, in 181.5, to say these institutions are accountable to the National Assembly and must report on their activities and the performance of their functions to the Assembly at least once a year. Now, I think the question then arises is, does the issue of cybersecurity fall within the family of those institutions and the rights that they protect and advance? I would argue, and this comes to my second point, that there are dimensions and aspects of cybersecurity that do indeed, because cybersecurity also involves issues of the right to information, the protection of information, rights of privacy. But I think cybersecurity goes beyond that, and there are also important dimensions of cybersecurity that involve more operational aspects of the state in general and of law enforcement in particular. And therefore the question would arise as to say, is it appropriate that one vests responsibility for cybersecurity in an entity which is, as section 181.2 of the Constitution says, institutions that are independent and subject only to the Constitution and the law? Are these not, in many respects, direct executive functions? And the question would be then is to say, have we sufficiently analyzed the nature of the mischief that we are seeking to address? I would argue that I don't, over and above the considerations and the concerns that have been articulated, I think very eloquently and comprehensively in previous presentations around the proliferation of institutions, the issues of cost, etc., and capacity, and so on. I just think that we need to ask ourselves the more fundamental question as to whether this is an issue that belongs in a Chapter 9 institution. I just want to add to say that I think there's another dimension to cybersecurity that is developing very rapidly that we must also not lose sight of. And that is the very, very rapid rise of artificial intelligence and the issues that that gives rise to, both in relation to cybersecurity, but also the rights of citizens. It's for that reason that I would concur with those who suggest that we maybe keep a more flexible approach to this matter, and that we invest our efforts in better coordinating and capacitating and empowering existing structures and initiatives. Chairperson, I conclude just by responding to the remark in relation to the State Security Agency and its involvement. I think we do need to correct that. I think the statement that the State Security Agency is unaccountable, I think is not true. State Security Agency, like any other government institution, is accountable to Parliament, and there are specific and special institutional arrangements in the form of the Joint Standing Committee on Intelligence that do provide fora for holding the SSA accountable. Thank you.
Thank you very much, TM. Advocate Lakula.
Thank you very much, Chair. Also, thank you very much, and I also welcome all the comments, and they are all very helpful. I think to Honorable Klopper, I think we state very clearly in our submission, and we agree with you, that cost should never be the main issue that militates against us addressing this vexed issue. And I think we are the ones who really deal with this matter, because whoever suffers a security compromise, which is a data breach, has to inform us. And we are sitting this year with 1,700 plus notifications of data breaches. So we are very much aware of the seriousness of this issue in our country. And we're saying this issue has to be addressed. So we're making our proposal on the back of the proposed constitutional amendment. We are saying, if at all, the Constitution is going to be amended to create this Cybersecurity Commission, let us rather then strengthen the information regulator and make it that institution. You know, so our proposal is premised on the basis of the fact that if it is possible, if this is going to be done, don't create another institution, strengthen the information regulator. And among all the bodies that are appearing before you, Honorable Chair, we are the newest. We are going through the pains of establishing a new institution. 9 years post our institution, the establishment of our institution, it's still we're still a very long way. Because to establish a new institution, and everybody knows, it's office space, it's a staff you have to train. So we're saying we already have that infrastructure. You just have to create another level, you know, another, not level, another chapter, or what can I call it? Whatever it is, section in the information regulator, because we are already dealing with some aspects of security compromises. And to the Honorable Minister, I hear you and I probably agree with you. What motivated or what motivates our proposal is that the proposed, I'm coming, can you give me just 2 minutes, Chair, with indulgence?
Okay.
To finish this sentence. what motivates our proposal is the fact that the proposed constitutional amendment talks about the new commission dealing not only with cybersecurity, but with other aspects of human rights. And that's what lies behind our proposal. Thank you very much.
Thank you very much. No, I heard you saying the Honorable Minister, so that's why I was asking.
I thought you said my time is over.
No, I was not saying that.
Oh, okay.
Thank you very much, DM. Thank you very much, the Chair of the Information Regulator. We have called this meeting because we knew that as when we are navigating through this private members bill, you will surely enrich our argument and you'll surely ensure that you help us navigate through and provide a proper direction of what must happen. So let's step off this the 20th proposed amendment bill and go to the 21st amendment bill. The information regulator, Advocate Tlakola, if you think that you wish to be excused in this one, as you are not present, us will excuse you. The department and NPA will remain with us for this lap of the meeting.
Thank you, Chair. Will be excused. Thank you. Thank you very much.
Thank you very much. Thank you very much. DM, we are on the 21st amendment bill now. Can we get the presentation?
Chairperson, thank you very much. I think the comments that I made at the beginning of the meeting pertain to this matter as well. Just safe to say that we really want to emphasize that corruption is one of the key issues that faces our country. It has a tremendously detrimental effect on all of our efforts to develop our country, and in particular to advance the objective of promoting inclusive economic growth and creating jobs. And the government takes it extremely seriously. We as a department and the entities within the broad justice family, in particular the National Prosecuting Authority and the SIU, are all very engaged in the fight against corruption. There's been extensive public policy work to look at what the most appropriate institutional arrangements are to take forward that fight. And the DG and Advocate Pillay and team will speak to that. But I think just to again reiterate that we really appreciate any thoughts, any inputs, including those made by Advocate Breitenbach, to enrich those debates, those discussions, those policy processes. But we do think that proceeding with that amendment at this stage would not be helpful and would really risk causing a duplication of processes, and rather those proposals should be input into those processes currently underway in the executive. But with that, Chairperson, if I could hand over to the DG and the DG Pillay. Thank you.
Thank you very much, DG.
Thank you very much, Honorable Chair. I will request DDG Pillay to upload. Maybe over and above what the DM has said, just to mention that the department was tasked by the Justice, Crime and Prevention and Security Cluster to work on the review of the anti-corruption architecture in the country. This was informed by the need to strengthen the whole architecture, and a regard was there to the fact that there are many different institutions with different mandates, some of them overlapping, and were then given the responsibility to start the work. You'll recall last week that during the State of the Nation address, the President did mention the fact that in this current financial year, the department will produce a report and will take into account as well
the work that is being done by the National Advisory Council on Anti-Corruption, NACAC. So that's the context that we wanted to give to this presentation, that there's that work that we have been directed to do, and we are continuing to do consultations with our colleagues, and we'll take it back to the cluster, which involves the other entities as well who do work in anti-corruption. But I'll ask the DDG to take the honorable members through the presentation. Thank you very much, Chair. Thank you, DDG Pillay.
Thank you, Chairperson. I'm just double checking. Is my screen visible?
Yes, it is.
Okay, thank you very much, Chair. This presentation will also speak to a quick introduction of what the bill is, and then some substantial and technical issues on the bill itself. The purpose of our presentation is to provide the Portfolio Committee with our comments regarding those substantial and technical issues relating to the Constitution 21st Amendment Bill. Chairperson, the rationale for the amendment bill as proposed is to establish an anti-corruption commission, among others, amongst others, and it will take an unacceptably long time for the NPA, particularly bearing in mind its interdependence on SAPS and the Hawks for investigative capacity to deal meaningfully and effectively with the enormous workload of grand corruption. The proposed amendment, according to the draft of the bill, states the following in the memorandum on the objects: an anti-corruption commission will concentrate on a strictly defined and legislated space, dealing only with large-scale corruption, large-scale grand corruption, and high-level organized crime. Chair, I think I'm sharing the incorrect presentation. My apologies. The correct presentation is Chairperson, please bear with me while I fix this.
No problem.
I think the thank you, Chairperson. I think this is the correct presentation. My sincere apologies. But the first slide was correct, and I would just like to move to the second slide. Just by way of overview, Chair, the substantial issues are centered around three key issues. One is on the feasibility of establishing a new constitutional entity. The other is on other initiatives that are currently underway. And then the third key substantial point will be considerations for the creation of a new Chapter 9 entity in the Constitution. We thereafter move on to the technical issues. I will request Advocate Sibela Micha to now take us through the presentation. Thank you, Chairperson.
Good morning, Chairperson and the honorable members, Deputy Minister and other senior officials. The presentation, maybe if I can switch off the camera. The presentation if I can switch off the camera. As indicated, the proposal in the bill suggests the creation of the Chapter 9 institution with the retention of the existing multi-institutional architecture with the same or similar mandates. The proposed commission will be tasked to, among others, to prevent, combat, and investigate any conduct that is alleged, reported, or suspected to involve serious corruption and high-level organized crime being conducted by a person who's holding a public office or any other person that, as a result of the corrupt activities or high-level organized crime. If we look at the bill, it also requires that all organs of state must annually in April provide the Anti-Corruption Commission with a written report on the measures that they would have taken towards the eradication of corruption and high-level organized crime. The question is raised on the duplication of mandates and efforts on the existing constitutional and legislative powers which are currently in existence and exercised by various law enforcement agencies. The duplication of mandates and the creation of the new structure presents a challenge with regard to the resourcing existing structures and a new proposed structure. It further creates reporting responsibilities over and above that which are currently in existence, such as reporting to Parliament. The next slide. Okay. The other initiatives that are underway, as indicated by the DG, the President on 28 August 2022 has established the National Anti-Corruption Advisory Council, which is NACEC, as a multi-sectoral advisory body to monitor the implementation of the National Anti-Corruption Strategy. As part of its functions, the NACEC was to advise on the strengthening of South Africa's anti-corruption architecture. The recommendation of the NACEC are still awaited. The other considerations for the creation of a new Chapter 9 institution in the Constitution are that the question may arise whether Chapter 9 of the Constitution is an appropriate chapter for the establishment of the Anti-Corruption Commission. It has been argued that a constitutional entity has certain safeguards, which, for example, through security of tenure, oversight, and independence. However, there are disadvantages that are associated with the entity established in terms of the Constitution, which, amongst others, will relate to the nature of the functions being primarily functions falling within the administration in government. It should also be considered that legislation may be amended with relative ease with the view of introducing improvements if an entity is created by way of a statute. Secondly, the safeguards on security of tenure can be established in legislation, and also the success of entities depends on resources allocated, the strength of its mandate, effective exercise of oversight functions, and the skill of people it employs. Success is determined in a multidimensional manner with various issues at play and interdependencies. The next slide. In paragraph 6 of the objects memo of the amendment bill, it is indicated that accountability now was consulted during the drafting of the bill. It is rather unfortunate that only one institution was consulted, which is a non-governmental organization, especially in view thereof that an amendment of this nature will have an enormous impact on the functions of numerous state institutions. The establishment of Anti-Corruption Commission will have a major impact on the fiscus. It is unfortunate that a provisional costing could not have been done to consider the possible financial implications of the eventual national legislation to be enacted in terms of the proposed Section 191 capital A of the Constitution. The next slide. Just dealing with the technical issues. The clause 1 of the bill refers to which we're going to call the Principal Act. This will be incorrect. The Constitution is not referred to as an act or a principal act. The Constitution should, in clause 1 of the 20th Amendment, be referred to again after as a Constitution, similarly to that which was done in the 20th Amendment Bill. Comparing the provisions of the 20th Amendment Bill with those of the 21st Amendment Bill, it should be pointed out that the two amendments contain provisions that are not aligned with regard to the qualification criteria. for the appointment of relevant persons. This point becomes relevant in so far as consistency of provisions when the rest of Chapter 9 is considered. For instance, some of the provisions for Chapter 9 institutions provide for periods of appointment between 5 to 10 years. The current Chapter 9 institutions perform what could be referred to as watchdog functions with powers of investigation to support their work. They are, broadly speaking, institutions supporting constitutional democracy. The proposed Chapter 9 institution is empowered to investigate high-level corruption, among others, based on a perceived inability of existing institutions to do so. It is, strictly speaking, not a watchdog entity supporting constitutional democracy as with the other institutions such as Human Rights Commission and the Public Protector. Setting out its powers in a national legislation would not be sufficient to address this concern, as its powers are primarily to perform functions that fall within administrative sphere of government. Neither is it advisable to premise the creation of a constitutional entity on incorrect perceptions. I think this will be the end of the presentation, Chair. I thank you. Thank you.
Thank you very much, Department of Justice, NTPP.
Thank you, Chair. Just want to, whilst we're flighting the presentation, if I could, good morning to the Chair, honorable members, the Deputy Minister, the DG, the Information Regulator, and other colleagues on the platform. So we appreciate and thank the committee for giving us this opportunity to present our submissions. I am joined here by members of my executive committee, and if need be, they will take questions at a later stage, as the chair decides, of course. Chair, as I mentioned, we didn't make any comments on the 20th constitutional amendment proposed. But of course, in due course, we will send comments to the Department of Justice, which leads on these issues, and as per the normal process that we engage with when we do input into various pieces of legislation. This presentation deals specifically with the 21st Amendment, which focuses on establishing a commission to deal with anti-corruption, corruption, and organized crime. I should clarify, Chair, at this point, is that it's not our intention to make technical submissions on the bill, which our view is it's premature at this stage, which I will elaborate on. But rather, we will give some perspective and context to ongoing processes, discussions on these issues, which should have a bearing in the consideration of the bill. I should also say at the outset, Chair, that as the National Prosecuting Authority and as citizens of this country, we want what is best for the country. And that is the attitude with which we approach this conversation. If we could move to slide 3, currently there are 2 processes, and you've heard about these processes that are being driven from the presidency, and it forms part of Cabinet's response to the Zondo Commission recommendations that were made to Parliament in October of 2022, and which in the view of the NPA do need to run its course. The first of the processes is the National Anti-Corruption Advisory Council process, which has been established by the executive, by the president, and consultations are being undertaken. And then, of course, the DG mentioned the other process, which the department's involved in terms of review of the South Africa's anti-corruption architecture. And so it's really important that these processes, are allowed to continue, and, and that their findings and conclusions actually inform the way forward on these issues. If we consider the bill at this point, it's our respectful submission, Chair, and without regard to these outcomes and proposals of these processes, as I mentioned, it would be premature and it will not have the benefit of the extensive research that is being undertaken in those spaces. The NACAC has consulted with many stakeholders, and which we understand has been the process. We have also consulted with them and had quite in-depth discussions based on international practices and also looking at our experiences in the South African context. They have been taking a holistic landscape approach to the anti-corruption landscape, and looking at the various functions, the mandates of the different entities, and in terms of deciding what ultimately their recommendations would be. So given the ongoing debate on the anti-corruption agency, including in Parliament, where many of these issues had been canvassed at the time of the NPA Amendment Bill, which established the IDAC as a permanent entity, we want to just take a little bit of time to recall some of those issues, and also bearing in mind that some of the members are new on this committee. We support as the NPA a multi-agency model, not a single agency, in the sense that it is a super anti-corruption agency that deals with the preventative side as well as the reactive side, law enforcement side. Basically, that encompasses the whole of the national anti-corruption, implementation of the whole of the national anti-corruption strategy, which focuses a lot on the prevention side of it. As you can see in this all of these various entities that are engaged in anti-corruption efforts. And it's our view, and we support the view that has been expressed, that, and also in the context of the cybersecurity discussion, that instead of establishing a new structure altogether, we need to first properly understand the challenges and why the existing entities are perhaps not delivering to the extent or at the levels that we would like them to do, and then to build on what is already there to reinforce that those structures. We support a model where there are different agencies specializing in different functions, as I mentioned, the prevention side and the reaction side. Prosecutions to vest in a prosecution-led model within the NPA, particularly in the IDAC. And I will talk later about some of the challenges and some of the criteria, in particular the STIRS criteria, that we agree with should be complied with. So I think this, I'll just skip that. We go to slide 6. So you do need to, in this model, look at enhanced coordination across agencies to minimize overlapping mandates and maximize available resources. And I think that has been one of the challenges that we've faced, is ensuring that there's effective coordination. And perhaps we need to look at how do we reinforce structures coordination structures, and perhaps maybe the need to create ministerial committees that make sure that the coordination and the resourcing across the various structures happen. Ensuring that agencies have the necessary capacity, capabilities, specialized skills, and other important resources to deal with these. And establishing a Chapter 9 institution does not guarantee independence or effectiveness. And so, we do need to have the resource, and I'll come back to that later in the presentation to expand a little bit more on that. The next slide. So in terms of this multi-agency model, the IDAC has been established as a permanent structure in the NPA. It's not dependent on presidential proclamation. So the real importance of this is the fact that, unlike the ID, which was, as we know, dependent on a proclamation that could be removed at any time by the president, one of the other weaknesses in that structure of the ID was that its resourcing was premised primarily on secondments from other entities. And this was a major challenge in the ID's existence, throughout its existence. And now that you have a permanent structure with a specialized mandate, we it's a huge move, and from where we were to where we currently are. The IDAC is being capacitated with permanent criminal and financial investigators. There's been, really swift recruitment processes that have been ongoing. In addition, in the context of the presidential initiative, we have established the Digital Evidence Unit to support the work of the IDAC. And the importance of this unit cannot be overstated. One of the key challenges in the IDAC has been and continues to be the issue of data analytics, data forensic analysis. And that has been, in fact, the setback in some of the key cases we've dealt with. And so the setting up of this initiative through this Digital Evidence Unit, through the presidential initiative, with support from business, is a huge step in the right direction in terms of getting the requisite resources that we need. I hasten to add that these skills are extremely expensive, but in addition to that, we are currently procuring those skills from external partners at considerable cost. So this Digital Evidence Unit will certainly, be a huge benefit to the IDAC as it continues its work. It has been only established in 2024, August, and so that's when the regulations were published. And so, it's really, we must give the IDAC time to properly set up and deliver on its mandate. And, with the recruitment that has been going on since August with the Digital Evidence Unit, I'm very confident that there's going to be a lot of progress in the IDAC space in the coming year. As I mentioned earlier, if you can move to slide 8, dealing with the STIRS criteria in the Glenister cases, we're still on slide 7. If you can move to slide 8. Are we not moving? Sorry, the slides seem to be stuck on slide 7. Chair, is that your experience as well? Are you seeing slide 7?
Yes, it's stuck on slide 11. So slide 7, sorry.
7.
Yes, slide 7.
Okay, we're going to try to, maybe we want to take this presentation down and try to reshare it. In the meantime, may I proceed, Chair? Or
Yes,
would you like me to, until we get that technical issue sorted out?
Yes, please proceed.
Oh, there we go. Thank you. So, Chair, in line with the Glenister cases, we support that compliance with the STIRS criteria. Specialized, trained, independent, resourced, and security of tenure. And dealing with each of these very briefly, I've touched on some of the resourcing issues, but dealing with them, specialization, as we said, we do require a specialized unit, and the IDAC currently specializing only in very complex and serious corruption matters. There is a provision in its mandate, though, to deal with more broadly, also with crimes under the Prevention of Organized Crime Act, for example. Trained, we have been recruiting personnel. We have been undertaking lots of training to make sure that the human resources have the necessary skills to deal with complex crimes. We are also have plans for substantial training this year, particularly from funding we've received through the German initiative, as well as training through the UK. So there's a lot of work done on capacitation and training of the staff. In terms of independence, this is the I in STIRS. This is a really critical issue. And these are issues that have been raised in the context of the proposed amendment, 21st Amendment. And certainly the establishment of the IDAC as a permanent entity enhances its independence in that it cannot simply be shut down by a proclamation. And I suppose it's security of tenure more than anything, rather than independence. But we must understand and remember that Glenister talks about having an entity being adequately independent. And so it must have sufficient attributes of independence to fulfill the functions that are required under the Constitution. And so the issue of a Chapter 9 versus the link to the executive becomes pertinent in this regard. And so, in our view, there's very few prosecuting authorities in the world that actually are completely delinked from the executive. So our view is that this link to the executive does not detract from adequate independence, as long as the functions and responsibilities are clearly understood and delineated. And importantly, there's no undue political interference in the work of any entity of the National Prosecuting Authority broadly. And I do want to say that we've been fortunate that the NPA has, in the past, since I've taken office, worked without any political interference. But I agree that can change. And it doesn't mean that it won't happen in the future, but you need to have these functions. That's why it's important to have clarification about the final responsibility of the minister in terms of the legislative framework as it currently is. We do need to enhance the issue of the financial and operational independence of the NPA. And this was also something that was debated quite extensively in Parliament during the debates on the NPA amendment bill that created the IDAC. And it's of all the anti-corruption entities, and this is really important, that's fighting, that has some mandate to deal with corruption, anti-corruption efforts, such as the police, the SIU, the FIC, IPID, and I suppose SARS could be with the tax-related cases that also link to corruption. The NPA is the only agency that does not have financial and operational independence, that does not have control over its own budget, recruitment, and various human resource issues. And this is something that we dealt with, as I said, in the discussions in Parliament, and explained the impact that this has on the operational effectiveness of the NPA. And this is something that has been raised for many years, and I am currently in discussions with the new minister on this issue as well. This issue was also mentioned by the president in his on behalf of cabinet in the response to the Zondo Commission recommendations. We've got the wording. I don't think I'm going to read that out, but it's for the committee can take note of that. But we are, as I said, in discussions with the new minister. Getting back to the resource issue, whether it's an anti-corruption, a Chapter 9 entity, or any other entity, if you do not have the resources, properly resourced entity, and this has been the biggest challenge for the ID, because of the secondment issue, and the current IDAC for various reasons. And I think one of the really, really important challenges in resourcing is the salary dispensation. And because currently the IDAC and the NPA is locked into the public service salary dispensation framework, we are not able to offer staff members that come with very scarce specialized skills the level of salaries we should be. Now, this is not a constraint that the SARS has. It's not a constraint that the SIU has. But so the NPA, like the information regulator, we are in the same situation where we are training people, spending a lot of money on this, but, some of them leave, because of greener pastures and better prospects. So unless this issue of the salary dispensation is dealt with quickly, we are continuously, it will seriously hamper the work of the IDAC as we move forward. So this is really an important issue that has to be dealt with. And I dealt with the digital evidence unit that is being set up, which will really assist us in this regard. We're also exploring the use of CARA funding to support that initiative as well. And then with regard to security of tenure, which is the S in STIRS, this is, you know, as I mentioned, you know, the permanence assists and helps in this regard. But we do think that we need to have further legislative amendments to deal with the appointment processes related to a national director, relating to deputy national directors and DPPs, who are all presidential appointments. And at the fourth level in the NPA, the level of chief prosecutors and deputy DPPs, the minister makes those appointments at that level. So there's a lot of these issues relating to appointments, and it's something that the president also mentioned in his Zondo response, that these are issues that need to be dealt with and addressed. So I think, you know, and there were commitments made by the previous minister to address the broader reform and these issues in amendments to the NPA Act. And we certainly hope that this will be a priority in the Department of Justice for the coming year in terms of these amendments, because they do impact on the issue of the independence and security of tenure issues. And just to make the point that, you know, I think one of the benefits of a Chapter 9 institution is that in order to remove the head of a Chapter 9 entity, you need 2/3 majority in Parliament. Unlike the head of the NPA or other presidential appointments, requires a simple majority in Parliament after a presidential process to agree with the president process or not agree. So perhaps an amendment to the NPA Act or the relevant legislation that deals with this, to increase this to a 2/3 majority, could actually address that weakness and enhance the issue of security of tenure. We've dealt mainly with corruption and with the challenges we've had in the IDAC. I think it's really important, as I said at the beginning, to properly understand the challenges and why currently the entities that are tasked to do this work is not able to fire on all cylinders. I've dealt with the various issues, resourcing being one of the critical issues, and we must be very careful that we don't throw the baby out with the bathwater, so to speak, and that we really look at this in a holistic way so that we build on the incredible capacity that we're trying to get into the NPA, into the IDAC, and also working with business and getting the assistance with the data forensics, that we look at these issues, that we thoroughly understand what exactly are the challenges before we decide to set up new institutions with duplicating mandates and which will actually face the same challenges if these are not addressed in the current contexts. We've dealt mainly with the IDAC, I mean, with the corruption issue, not with the organized crime part of it. It's not in my presentation, but just a few words on this. You know, we've got to accept, if one looks at all the research that's been done, including by the Global Initiative on Transnational Organized Crime, who also did a presentation at the JCPS and to the ministers, the JCPS Ministers Cluster. Organized crime is an existential threat in this country. And the sad reality is that we are not getting to grips with organized crime in this country. And of course, there are links to corruption at the organized crime model is to one of the business risks of organized criminality is that you get investigators who investigate you, you're prosecuted. And so what are one of the risk mitigation measures is you corrupt these people, including, powerful politicians, those in law enforcement, even the prosecution. So that is a real challenge that we are having. Having a very well-capacitated crime intelligence capacity is critical to dealing with organized crime. And so even though there are pockets of excellence, I must say, for example, with dealing with organized criminality in the Western Cape with many of the gangs, we have some of the top gang leaders that are in court currently at the moment. So there are certainly pockets of excellence, but not by any means do we have the capacities and capabilities at the level we need to be dealing properly with organized crime, starting right from crime intelligence, moving right through the entire system. And also, we've got to accept, well, GTOX, one of their research has shown that there is one of the big risks to law enforcement is corruption within the ranks of law enforcement. So one has to really give important consideration to how do we deal effectively with organized criminality. And, you know, perhaps there's a need to expand the mandate of an IDAC type prosecutor-led model and looking at, but any setting up of any organization like that has got to really, we've got to make sure that in that process, how do we ensure that we have the resources, the human resources that are those of the highest standards of integrity to start off with? And how do we ensure that? Because people can start off with higher standards of integrity and then it changes. You know, you get corrupted by organized criminals who have a lot of money at their disposal. So, you know, looking at and creating, you know, a capacity, for example, expanding the IDAC mandate to recruit very purposefully, dealing with lifestyle audits, having, you know, the very, very meticulous recruitment standards to recruit those that one can say are of the highest standard of integrity and getting the right skills, which will also talk to the salary issues that I mentioned earlier. And ensuring that there are safeguards to ensure, like random lifestyle audits. So, you know, it doesn't have to be everyone all the time, but, you know, X knows that or doesn't know when they be called up for a lifestyle audit or some kind of, you know, whether it's also looking at lie detector tests, you know, having very, very stringent processes to try to ensure that we can maintain a corruption-free environment in that space. So I think this is something that really needs to be dealt with as we move forward. In conclusion, I'd just like to say, you know, that like many other countries, we are facing challenges in ensuring accountability for serious and complex corruption matters. This is not a uniquely South African phenomenon. There in many fora that, you know, we are engaged in across the world, prosecutors are struggling, and even well-resourced jurisdictions are struggling with getting corruption cases to move swiftly through the system because of, you know, tactics, including like the Stalingrad tactics. So this is across Africa. I've spoken to prosecutors. This is a challenge that many prosecuting authorities are facing across the world. But we got to continue to fight this and not accept that that is the position. But just to contextualize that fighting corruption is not easy, and corruption fights back, and often dirty. So, you know, the IDAC also, you know, as part of a criminal justice system, and this is not just about IDAC, it's about any organized crime entity any entity that's going to be dealing with organized crime, is part of the value chain. And we have to make sure that across the value chain, as I said, right from crime intelligence through to prosecutions, we ensure we have the necessary skills, we have the necessary capacities, we're able to pay people at the right levels and retain staff, retain a corruption-free environment in order for us to have any chance of being able to deal with organized crime and corruption, and then to ensure that we comply with all of the other STIRS criteria that I mentioned. I want to emphasize that the IDAC is still relatively new. We should give it time to deal with these issues, to capacitate itself. And as I mentioned, I'm confident that with all of the added powers and capacities, there will be significant improvement in dealing with corruption in the coming year. I think those are my comments. We will continue to engage with the NACAC and with the Department of Justice to ensure that we have what is the best for the country, the best solution. I thank you, Chair, honorable members.
Thank you very much, NTPP. Hopefully members got that part that says fighting corruption is not easy. It fights back and often militate. So I hope they got that part.
Also, and Chair, maybe if I may, just to say that it also requires that you have prosecutors, and this is part of what makes it very difficult. Not to speak about witnesses who are reluctant to come forward, witnesses who fear for their lives, prosecutors who have to be, protected and who are in very intimidating and difficult environments to deal with these cases. So it's not just about the resources, just a holistic approach that makes this very difficult, but we're committed to continue the fight. Thank you, Chair.
Thank you very much, NTPP. Members, any interaction with both these presentations? Honorable Mhlala, it seems like you're the only one now. Honorable Swart, Honorable Klopper, in that order.
No, Chairperson, I was just requesting maybe the presentation that was presented by the NDPP to be forwarded to us. We did not receive, but anyhow, let me just start and also make my engagement on these two reports from the Department of Justice and the NDPP. Chairperson, I think both the entities provided us with a very good presentation, and that is informative, even though we did not get the one of the NDPP. But what I want to say, Chairperson, is corruption in South Africa is not just about individual criminals. It is deeply tied to the structure of the state and the economy, where the ruling elite, the corporations, and government officials collude to extract wealth at the expense of the people. The state has already established multiple anti-corruption institutions like the NPA, the Hawks, the SIU, the Public Protector, but they failed due to political interference. I heard the NDPP saying that they are the only entity that doesn't have those things. But according to how we see things, we see them as being compromised as an entity. The lack of funding, Chair, and deliberate weakening by the ruling party. The bill does not address the structural causes of corruption, such as the state capture, the corporate collusion, and elite enrichment at the expense of the working class. So, the second point, Chairperson, is about the duplication of existing institutions, a bureaucratic expansion instead of real reform. The National Anti-Corruption Advisory Council, the NECAC, created in 2022, already exists to monitor corruption and advise on strengthening anti-corruption policies. The bill creates another oversight body instead of empowering and properly funding existing anti-corruption structures. If the government is serious about fighting corruption, it should strengthen the NPA and the Hawks by ensuring that they are free from political interference and properly resourced. Implement real accountability, mechanism that allows citizens to take action against corrupt officials without waiting for slow state intervention. The third point, Chair, is on financial concerns. A new institution in a struggling economy. That is my point. The bill does not provide a cost analysis for setting up the Anti-Corruption Commission. Creating a new Chapter 9 institution requires massive funding for staff, investigation, and operations. Given South Africa's economic crisis, high unemployment, Chair, failing service delivery, and increasing inequality, does it make sense to spend billions on another bureaucracy when existing institutions are underfunded? Redirect funds to worker-led anti-corruption initiatives, community-based accountability structures, and direct support for whistleblowers who expose corruption. Chair, the Chapter 9 institutions are meant to be independent and protect democracy. But in reality, they've often been politically manipulated by those who are in power. We saw previously the issue of Phala, how it ended, the issue of Bosasa, how it ended. All those things, they don't have any way forward of what is that we must do as a country when we face something like that. The bill argues that a Chapter 9 institution will be free from political interference. That is not correct. But South Africa have seen how institutions like the Public Protector and the IEC have been captured and used for factional battles. In elections, IEC, they take charge, they become the government themselves, they protect the current government. We saw them, we are on the ground, we are seeing all those things. So we don't believe in those things of just duplicating institutions. Instead of another institution that might be vulnerable for political interference, the focus should be on ensuring true independence for existing anti-corruption bodies. Thank you, Chair.
Thank you very much, Honorable Swart.
Thank you, Chairperson, and thanks to the DM and the department and the NPA for in particular the NPA for their inputs, which were very helpful. I fully appreciate the challenges that IDAC faces and the proposal to allow it to find its feet. We know, we as Parliament, when it comes to resources, we pass the budgets, we understand the budgetary constraints. What I do want to remind us is that when we considered the bill, the then Deputy Minister made it very clear that the whole process of that amendment bill was almost an interim measure pending the findings and recommendations of the National Anti-Corruption Advisory Council. What we now know is that the National Anti-Corruption Advisory Council, who will be making a presentation to us, has recommended a Chapter 9 institution after much research recommendations. They've come to that conclusion. They call it the Office of the Public Integrity and Anti-Corruption. So it seems there is support for the concept of another Chapter 9 institution. There is also support in civil society. And yes, the point was well made about consultations, but I do think this will be an ongoing process where further consultations can be made. I think the NDPP correctly pointed out the fact that as far as the STIRS requirements are concerned, there are issues there, particularly when it comes to the issue of resources. And I fully appreciate the constraints that the NPA and IDAC suffer as a result of resource constraints. However, there are a number of very important points which are put out in the memorandum, which we as a committee will need to consider. And I think one of the most important of which I did notice the NDPP did allude to, is that the protections under STIRS, should they be encapsulated in a Chapter 9 institution, can only be amended by a much higher majority, and it's not ordinary legislation. So these are some of the issues we do need to look at. But what I would like to ask specifically is that issue has not been dealt with by either the department or the NPA, that the National Anti-Corruption Advisory Council has made a recommendation of Chapter 9, of a Chapter 9 institution, and maybe we need to be updated on that. They themselves would address us, but maybe we can hear as well from the department and the NPA on that score, and maybe they can also add with their submissions at a later stage. I do also appreciate what the NPA has said about other amendment bills to enhance their independence and operational and administrative independence. Those are issues which we do need to definitely look at. But I think at the end of the day, when one considers the motivation in the memorandum that the NPA and other law enforcement agencies are struggling with their workload. Now, the question at the end of the day will be to follow the recommendation of the National Anti-Corruption Advisory Council to set up a separate Chapter 9 institution, whatever that process is ongoing, to look at this model that is presented by Advocate Breitenbach, but clearly needs to be done. I would submit the NDPP indicated that organized crime is an existential threat to South Africa. And I think corruption is similarly an existential threat to South Africa. But with those short comments, I await the inputs particularly from the National Anti-Corruption Advisory Council. Thank you, Chair.
Thank you very much, Honorable Swart. Yes, NECEC is still coming. Honorable Klopper.
Thank you, Chairperson. As far as mandate duplicity, I think what is important to take note is successful prosecution of individuals implicated in high-profile cases such as in the Zondo report. There's little to no success, and this cannot be solely attributed to resourcing only, and hence this is the reason for the proposal. I'm not convinced that it's a duplicate mandate, but rather a proactive step in actually successfully executing the mandate. As far as reporting responsibilities, the report would have been sent to Parliament, would be sent to the Anti-Corruption Commission. Cannot see why this would be an extensive burden, and should the need for the Commission not to have been needed in the first place, then the so-called burden would not have been needed either. Chairperson, the National Anti-Corruption Advisory Council, first announced by the President Ramaphosa in 21 at the SONA, was appointed a year later in August 22. A year ago, we were told that the recommendations were imminent. When will these recommendations reach the portfolio, and what is the time frame connected to this? Consider that while we wait for reports and recommendations, there's implicated individuals roaming free from successful prosecution. The DG mentioned the department was tasked to also draft a report on the anti-corruption architecture. But there's once again no further information, no clear target dates and timelines. It is somewhat strange in such circumstances, and given the scourge of corruption in this country, that this bill is not treated more seriously. Also because of our weak anti-corruption actions, we're still part of what we remain grey listed. Chairperson, as Chapter 9 suitability is establishing the Commission as a Chapter 9 entity would provide it with necessary independence and oversight to effectively combat corruption. The Anti-Corruption Commission can be designed to include both investigative and watchdog functions, ensuring this supports constitutional democracy while effectively combating corruption. The department says current Chapter 9 institutions are only watchdogs, and this makes a proposal unsuitable. But of course, that's not completely accurate. Chairperson, the Human Rights Commission has powers to embark on formal legal action, as it's very well known that the Concord determined that the public protector makes binding findings and not just mere recommendations. Even the AG's powers have evolved to now including being able to legally hold officials responsible for wasteful expenditure. As it is, Chairperson, what we need in this country is a constitutionally enshrined corruption-fighting agency, which cannot be disbanded through ordinary legislation, something that could easily happen with the investigative directorates of the NPA. When we talk about architecture, it's essential that our corruption-fighting entity must at least know that it enjoys the constitutional protection, even if the NDPP now suggests that it will not guarantee independence. We maintain constitutional protection still gives an institution the best chance to be independent and effective. Chairperson, all said and done, as the proposed bills by Honourable Breitenbach, there will be responses on a separate occasion, considering all the comments and suggestions and so forth. And what's more important is that we don't mind whose legislation is adopted at the end, as long as effectively addresses the serious issues we face. And we are also very happy to cooperate and assist wherever possible. Thank you, Chairperson.
Thank you, Honorable Zotetsi.
Thank you very much, Chair. Chair, mine is just brief. My concern is when we intend to concentrate the entire effort of fighting corruption into a single entity. And I think that becomes a bit dangerous because in an event such an entity collapses due to areas which are informing our concern currently with regard to other entities. One of the issues you would have there would have been mentioned earlier on, the question of corruption within these law enforcement entities. No one says that the new entity to be established will be immune from such. Now, in an event that it gets affected by such, you are basically saying that all the corruption fighting effort would have collapsed, and you can imagine what then will happen with the country. And our diverse strategy through various entities of fighting corruption, I think to a large extent have been able to be effective with just needing to be strengthened there and there. Why am I saying that? Many people would have argued that with the weakening of various entities in the fifth and fourth administration, you would have other entities that were supposed to come straight up in the fight against the capture of the state, which didn't. But the reality is that one of the entities would come through in the form of the Public Protector's Office and point out some of the issues. Now, that means that there couldn't have been a total capture of all the entities and so forth, and that was able to assist the country to see the light of day. Now, one sitting here, I can only imagine what then happens if all the strategy is centered around a single entity and its responsibilities to assist us in that regard. I think that becomes a bit of a challenge. I think similarly to what we were dealing with earlier on around the question of the Cybersecurity Commission, this would also fall around. Will fall also into the same explanation to say what is required of us is to thoroughly examine what informs the weaknesses on entities that we already have. Ms. Badoi articulated some of the issues that she thinks are the concerns around the National Prosecuting Authority. And all these other entities may have some of the areas of weaknesses, which I think a thorough examination and a very serious approach in improving their operations would be able to assist us, as opposed to, and again we mentioned, the continuous appetite of establishing entities and the amendment of constitution when there is really a space and an opportunity for us to empower the existing entities and ensure that the very same results which we want are able to be sourced. We agree. I would want to agree with Honorable Musala, I think, on the question of the existence of these entities. Of course, as a new member of the committee, there would be an appetite there and there of grandstanding on a part. But I think that some of the input which would have made around the weaknesses of these entities and the capacity really of the current parliament to participate in strengthening those entities has not been tested, and it should be tested. And I think that is going to be able to succeed. Thank you very much, Chair.
Thank you very much, Honorable Tsotetsi. DMNL, any parting shots before we conclude?
Chairperson, thank you very, very much. Yes, and again, thank you very much to both the presentations and the interventions by members. Just a couple of points. Firstly, I think in relation to the Honourable Muhlala, I think she points out very correctly that in fighting corruption, we do need to have a broader understanding of the factors, including the structural factors in our society and our economy, which drive corruption. However, I do think, Honourable Chair, through you, that it would be important for members of the committee to maybe exercise some restraint in the eloquence of their expression when it comes to the integrity of our Chapter 9 institutions. And I think to make general statements attacking the integrity of those institutions without adducing proper evidence is quite dangerous, because as we know, as Goebbels, the German propagandist, said, that a lie that is repeated often enough sometimes starts enjoying the status of truth. So I would really implore that we do exercise some restraint in how we discuss those very important and sensitive matters. Secondly, I think the Honourable Swart, I agree fully with his emphasis on the need for urgency. I think just to say that, yes, the NACAC has made certain recommendations. Those recommendations are currently enjoying attention and processing within the executive. I think it was mentioned earlier, I think it might have been by either the DG or the DDG, that there has been a presentation to the JCPS DG's cluster at a ministerial level. That briefing has not yet taken place. We are pushing for it to happen as quickly as possible. But the result of that is that whilst there's been very thorough and comprehensive work done, the processing of it hasn't been finalized. Once it is, and we've also had the opportunity of taking it to Cabinet, I think it would then be appropriate to bring it to the committee, for the committee to engage and interrogate it as thoroughly as it always does. So at this stage, I think it would perhaps not be the wisest course of action to proceed on the basis of a recommendation contained in a report that hasn't been thoroughly and finally processed yet. We understand and we share the sense of urgency and impatience, but I think experience has also taught us that sometimes the quickest way is not necessarily to rush, but also to be thorough and methodical in our approach. The third point is in relation to the Honourable Tsotetsi. I think he raises an extremely valid and important matter that we need to consider very carefully as we look at the design of our anti-corruption architecture. One of the characteristics that defines some of the systems that are designed to deal with the most serious assaults and challenges, be it in the field of military or in the field of communications, is the issue of building redundancy into your systems, so that if one system fails, there'll be another. If that one fails, there'll be another. I think it's whilst it is a very seductive approach to say, let us consolidate, let us pool, let us strengthen and concentrate. There are also dangers inherent with that. If it's the old proverbial situation of having all of your eggs in one basket. And I think we do need to take seriously our very, very painful and quite recent experience of state capture, how institutions were sought systematically to be undermined and hollowed out. The fact that in the wisdom of the drafters of our constitution, we had put in place a constitutional architecture that had multiple institutions, I think enabled us as a country to survive that dark chapter in our history, because even though some institutions were compromised, others were able to continue and to discharge their constitutional mandate. Chairperson, in conclusion, just to revert to where we started, and that is again to welcome the initiative and the efforts by the Honourable Breitenbach. I think that her proposals put forward some very provocative ideas that can serve to enrich a process within the executive and which will unfold also in Parliament, a process in the executive that is already at a very advanced stage and which we hope to be able to report to Parliament in the not too distant future. And accordingly then, I think it would be premature to proceed with the proposal when those processes have not yet been finalized and the committee would not yet have the benefit of the information and the insights and the proposals contained in that work. Chairperson, thank you very much.
Thank you. And TPP parting shots.
Yes, thank you, Chair. Chair, thank you again. And just on the Chapter 9, the NACAC recommendations, which Honourable Swart mentioned. Look, NACAC will be presenting, so I'm not going to try to explain their recommendations and misinterpret it at the risk of misinterpretation. But I think at a very high level, Honourable Swart is correct. They do recommend a Chapter 9 entity, but to deal with the preventative aspects of corruption primarily and a limited investigative capacity, but no prosecutorial powers. And so that is my high level understanding of that. And the thinking would be that quite a bit of the mandate of this OPI that they are calling Office of Public Integrity would be to look at systemic corruption in the systems that actually enable corruption in various departments and entities, and to deal more with the preventative side of it, and to look at the SIU mandates. And so in terms of the resourcing of a Chapter 9, the thinking is that the work of the SIU would kind of would be the foundation to build upon in the new entity. But I emphasize again that the recommendation is not that it would have any prosecutorial powers. And I think just, to mention, Chair, that we really welcome, again, this debate. We want what's best for South Africa. We welcome constructive criticism, for the work that we do. But I think it's the unfair attacks against the NPA because of the difficulties which prosecuting authorities face when it comes to dealing with grand corruption, that actually serve, whether it's political or personal agendas, don't help any one of us. And I think it's what Honorable Chotetsi said actually is an important point, is let us have a sober and an important assessment of what are the real challenges, whether they relate to systemic, whether they relate to resourcing, whether they relate to the operational and financial aspects or the broader reforms in the NPA, the skills that are needed. Let's properly understand what these challenges are, and then ensure that we are able to protect and build on existing institutions to make sure that they are able to deliver on their mandate. And as I said, let's just harness our collective brain power for all of us that really value the rule of law and that want, corruption and organized crime to be dealt with, to look at what's best for the country and come up with it. To scapegoat the NPA for narrow interests benefits no one. I really welcome the discussions in this regard. Thank you, Honorable Chair, Honorable Members.
Thank you very much, NTPP. Members, there is no doubt that we are committed in fighting corruption. We are committed in being proponents of a fight against any form of malfeasance in the country. The fact that we have signed our oath was a commitment on our part in ensuring that we help the country evade these kind of criminal activities. So we are now, pursuant to that kind of commitment, we are now trying to devise means to ensure that we help the state to fight corruption. But beyond that, we help the people of South Africa as a whole, whom suffer the most as victims of these corrupt activities. Of course, we have initially invited the National Advisory Council, Anti-Corruption Advisory Council, but we could not proceed the hearing with them because a lot of issues that they should have went through, or a lot of processes that they should have undergone, they have not yet undergone. They indicated themselves that they want to come and contribute towards this conversation we're having in the committee. But upon us establishing that they are actually supposed to first have a presentation to the president and later to cabinet. And those processes they have not yet done. So we said the best way is that all this must not start in the level of parliament, but rather it must start in the executive level. So that whatever that comes as a report or recommendations to parliament must have been agreed upon in the executive level. So that's one of the reasons why we have not we withdrew the National Anti-Corruption Advisory Council. It was an advisory council to the president and an extension to the cabinet. So we will implore the Ministry of Justice to help them undergo the necessary processes so that we as well are able to have that kind of a meeting with them. Because I think what they are, they may be recommending. We may not take it as it comes, but I think there are elements where they may actually be able to strengthen our argument in whatever direction we take in relation to this proposed private members bill. I see members were agitated to firmly bring forth their views on what must happen, on what had happened, and what are the problems and stuff. I think part of what members you must recall is that we have called these institutions to try get living experiences of what are the issues that are underpinning the fight against corruption, the fight against cyber intrusion and stuff. So we wanted them to come and enrich what would be the committee deliberations in relation to a decision that we ought to take on what must happen to the bill, whether we adopt or we don't adopt the bill, so that we're able to compile our own report to the House. So we take note of the issues that you have raised, members, all of you. And I think it is important that at this particular stage, we refrain or we exercise restraint in attacking the existing institutions that ought to fight crime. Yes, of course, it is important that we all pinpoint or pin out what we think are the challenges that they are facing. But the issue is we have called these institutions to ensure that they are actually the ones who present the actual issues. And beyond that, help and capacitate our own thinking in terms of how then will you approach the proposed private members bill. We note there's a constant proposal that we must have a consultation with the National Treasury. This emanates from the fact that I think both the department and the information regulator and NPA, even members actually allude that part of what may be missing from the perspective of this private members bill can be an issue relating to the funding model. How are we going to finance this institution so that it does not become a white elephant that is established, but does not actually execute what it has been established for? So what we'll do from now, members, we are going to have our own deliberations as the committee, alone as the committee, not in the presence of other institutions, to actually deliberate on the actual substance of the private, both the private members' bills. Then from there we'll decide on what must happen to the future of the pool, whether we don't adopt it or we adopt it, then make our own recommendations and the report to the House. So members, with that being said, we're coming to the conclusion now of our meeting. The department, we always appreciate that every time we seek your own submissions in a particular matter relative to your work, we always show up without any excuses. We don't have to go a route of using the powers, privileges, and immunities of Parliament Act to summon you and stuff. You always come forth to ensure that you do the best you can to help the committee execute its work and ensure that it meets its own targets. And by that, we're very appreciative. And NTPP and the information regulator in absentia, we appreciate the fact that you came to enrich our own work as the committee in trying to navigate through attending to a private members bill that has been brought before us by a member of this committee. And the issues that you have raised, even that are related to IDEC, we have noted as living experiences that must direct how we approach a possible new Chapter 9 institutions to fight corruption. So we really appreciate the submission and the contribution towards the work that we're doing. Members, we are going to indicate when possible can we get the National Anti-Corruption Advisory Council, and when possible can we have a submission from the National Treasury specifically focusing on issues relating to the funding model, because I can even hear from the submissions by members that some believe that the funding model is one of the backbone argument that the private members bill must actually bring forth, and some believe that the funding model and the resourcing impact mustn't really be the center of the argument of the bill. So that actually requires us to have a submission from the National Treasury. In the event where we can't find both NACEC and the National Treasury, we can even go to an extent of requesting them to just make written submissions that we're going to look at when we go for deliberations. Members, with that being said, we have now come to the end of the meeting. We are wanted in the House for the SONA debate. We are all thanked and appreciated for having contributed to this meeting. Thank you very much, members, and the meeting stands adjourned.
Thank you, Chair.
Thank you
Thank you,
very, very
Chair.
much,
Thank you.
Chairperson and
Thank you.
members.
Thank you, Chairman. Thank you, Chairman.
Recording stopped.
Thank you, Chairman.